The Fair Labor Standards Act, or FLSA, outlines the standards that U.S. employers must follow to pay rightful wages, keep proper wage and payment records, and regulate the employment of children and youth. In this training, you'll learn how to interpret and comply with wage standards, off-the-clock prohibitions, overtime requirements, child labor standards, and record keeping. You'll also learn about exemptions, enforcement policies, and other considerations for your business, such as nursing mothers. Let's get started. To properly understand and comply with the FLSA, it's important to understand the Act's established terminology. Here are the definitions and distinctions you need to know. An employee is someone who works exclusively for a singular business, receiving a regular hourly wage, salary, or piece rate payment for their labor. An independent contractor receives payment per individual project and may work on multiple non-exclusive contracts at a time. Employees are subject to the FLSA. Independent contractors are not. A work week is 168 hours, split into 7 consecutive 24-hour periods. That is used to determine workers' regular and overtime payments. Businesses may begin and end the work week on any day and time of their choosing to establish the baseline for employee compensation, requirements, and exemptions. The Department of Labor considers 40 hours to be a standard work week. Hours worked includes all time an employee was on duty, on premises, or at any other assigned work location, from their first work-related activity of the day through their last. Employees must be compensated for all hours worked. Exemptions are conditions that release employers from the terms of the FLSA, but they are often industry-specific and fall under limited circumstances. The Department of Labor supplies numerous fact sheets outlining all applicable exemptions. All workers covered by the FLSA must receive hourly compensation or salary equivalent to or higher than the current federally mandated minimum wage. All employees must also be paid at a rate of not less than 1.5 times their hourly rate that exceed 40 hours of work within one work week, which is the federal standard. Tipped employees may be paid hourly at less than the standard minimum wage, but no less than the current federally mandated minimum wage for tipped workers. Employees must be able to show that workers regularly receive enough compensation and tips to raise their wages to the standard minimum wage. Employees are entitled to their full tips, either independently or in a fair, valid tip-sharing pool. Compensation in the form of room, board, or other accommodations must be at a reasonable rate, and wage deductions for uniforms, tools, or other job-related equipment or expenses may not be large enough to reduce the employee's hourly rate below the federal minimum wage. Here's what you need to know. Hourly non-exempt workers cannot work off the clock, either of their own volition or at an employer's behest. Employees must be compensated for all work-related tasks, and the time they spend doing them must be recorded and paid accordingly. Anything otherwise is wage theft, which is punishable under the FLSA. As mentioned earlier, all workers that exceed 40 hours of work within one work week must be paid at least 1.5 times their regular rate for the excess hours. Take a look at these examples. If an hourly wage earner works 45 hours in a week at $25 per hour, they must be compensated for the extra 5 hours like this. 40 hours at the regular rate results in $1,000 of regular pay. 5 hours are calculated at time and a half. This brings their total compensation to $1,187.50 for the week. If an employee is paid on piecework and takes 45 hours to produce their allotted number of pieces, then determine their regular hourly rate and overtime compensation like this. Their piecework rate is multiplied by the number of pieces produced. The amount of money earned is then divided by the hours worked. In our example, this would be $1,125 divided by 45 hours. That equates to $25 per hour. After 40 hours, time and a half is applied as overtime. Adding this in provides the total weekly pay. If an employee earns a set weekly salary and works 45 hours in a work week, they are entitled to overtime compensation. That can be calculated as follows. The weekly salary is divided by 40 hours. Total regular pay is calculated as the hourly rate multiplied by 40. Time and a half is then applied to any hours over 40. Adding these together determines the total weekly pay. Of course, all these calculations show compensation before any taxes, garnishments, or other deductions are removed. Special consideration needs to be taken concerning the employment of minors, which is anyone under the age of 18. Employees over the age of 18 may work any job, agricultural or non-agricultural, hazardous or non-hazardous, per the standards of the FLSA. For non-agricultural jobs, the guidelines for minors break down as follows. Ages 16 and 17 may perform non-hazardous jobs without limit to hours. Ages 14 and 15 may work outside of school hours in non-hazardous, non-mining, and non-manufacturing roles for up to 3 hours on a school day and up to 18 hours in a school week. Up to 8 hours on a non-school day and up to 40 hours in a non-school week. Additionally, 14 and 15-year-olds may not begin work before 7 a.m. or end work after 7 p.m., except from June 1st through Labor Day, when they may work until 9 p.m. For certain work experience and work study programs, exceptions may be made to allow 14 and 15-year-olds to work during the school day. Minors may also engage in fair labor work at any age in certain circumstances, such as the entertainment industry, family-owned, non-hazardous, non-farm businesses, and in odd jobs such as delivering newspapers. Here's a breakdown of permissible farming jobs. Age 16 and above may perform any job, regardless of hazard, without limit to hours. Ages 14 and 15 may perform non-hazardous jobs outside of school hours. Ages 12 and 13 may perform non-hazardous jobs outside of school hours with a parent's permission or alongside a parent on a non-owned farm. Minors under 12 may perform non-hazardous jobs outside of school hours on parent-owned farms with permission or alongside a parent on a non-owned farm and/or farms not covered by minimum wage requirements. Minors of all ages may perform any job on a farm owned or operated by parents. While how employers keep records is at their discretion, what records need to be kept is not. To avoid non-compliance, keep records of personal information like full names, home addresses, job titles or occupations, and sex for all employees, plus the date of birth of employees under 19 years of age. Hour and day when the work week begins. Total hours worked each day and week for each employee. Total daily and weekly regular earnings for each employee. Total daily and weekly overtime earnings for each employee. Deductions or additions to wages for each employee. Total wages paid per pay period. And also the date of payment and the pay period it covered. These records apply to all non-exempt employees working under the regular standards of the FLSA. Additionally, all employers with employees covered by the FLSA must post the official Department of Labor FLSA Employee Rights and Minimum Wage Notice somewhere that all employees can reasonably access and read it. This poster is available in several languages. FLSA compliance is monitored, and complaints are investigated by Wage and Hour Division agents who work from field offices located throughout the United States. If violations are found, reparations will be enforced as follows. Agents will recommend and monitor corrective action plans. The Department of Labor will recover on behalf, or an employee may recover on their own behalf, back wages and unpaid overtime within a 2-year statute of limitations, or a 3-year statute of limitations for willful violations, either through a court order, injunction, or civil suit as filed by the employee. When recovering back wages and unpaid overtime, the Department of Labor is authorized to directly supervise the process. The Department of Labor may seek settlements in lieu of civil litigation. The Department of Labor may assess civil monetary penalties for child labor violations and repeat or willful violations of minimum wage and unpaid overtime, and/or record-keeping violations. Each violation carries an individual civil money penalty, and repeated or willful violations may result in criminal prosecution. Repeat violations of child labor standards, especially in the case of injury or death of a minor, carry escalating civil money penalties and may result in criminal prosecution. Criminal prosecution for violations of the FLSA may result in fines and possible imprisonment. Retaliation against employees who file complaints is strictly prohibited by the FLSA and may also result in penalties. Beyond the basics of the FLSA, there are some other considerations needed for a completely compliant workspace. Accommodations, including a private space that is not a bathroom, plus break time as needed, must be provided to nursing mothers so that they may pump or express breast milk. These accommodations must be provided for a minimum of 1 year after the birth of the child. The size of your business and state and local laws may also come into play when providing space for nursing mothers, so be sure to take all regulations into account. Under limited conditions, employers may compensate employees at less than the mandated minimum wage. A permit is required from the Wage and Hours Division to pay sub-minimum wages to individuals who include, but are not limited to, full-time students or work-study students, and those with physical or mental limitations that preclude them from working at full capacity or production capabilities. Employees under the age of 20 may be compensated at a federally mandated lower minimum wage during the first 90 consecutive calendar days of employment. Employers are strictly prohibited from displacing or reducing the hours of other full-wage employees to hire more youth-wage employees. The FLSA protects employees against unfair wage practices and provides standards for the employment of minors, but it does not regulate paid or unpaid vacation, holiday or sick time, severance pay, breaks, meals, rest periods, holidays or vacations, pay increases, perks and/or benefits, and the discharge of employees, the reason for discharge, or the immediate payment of final wages. However, state and local laws take on a heavy role in the execution of these items, so each employer should familiarize themselves with those statutes and regulations to ensure compliance. While the FLSA may seem complicated, it doesn't have to be. The FLSA is designed to protect employees, but it also provides a solid framework for best wage practices and child labor standards. Compliance is as simple as keeping clean, detailed records, following the guidelines for minimum wage, overtime, and youth employment, and availing yourself of the resources provided by the Department of Labor.